Howdy, folks. This is Kyle Graves at spacelawdigest.com, kylewgraves.com, and you can find my podcast in Apple Podcasts, Spotify, and the other places. I'm an intellectual property lawyer, and it's been a while since I've had a video for you, but today I want to address a topic that I've been thinking about for a long time. Previously, we talked about patents in space. We went through the treaty regime, we went through some maritime law examples, and talked about how, as space becomes increasingly commercialized, patents may be used in that context. Well, today is a related topic, but somewhat different in conclusion. Today we're talking about trademarks in space. Now, as many of you know, a trademark is a word, phrase, logo, or even a sound or a smell that operates in the mind of a consumer to identify the source of a particular set of goods or services. Now, trademark law protects the accumulated goodwill and commercial recognition that a company builds up over time. Now, they build this goodwill up over time by providing high quality goods, good customer support, or reliable and consistent consumer experiences. A brand owner will spend a lot of time and a lot of effort to make sure the brand is associated with good value for customers. So, naturally, it would be unfair for a competitor to use the same name and deceive consumers about the origin of products, especially after the brand owner works to build up the market recognition for that product. So, conventionally, trademarks are a regional thing. They're a regional right. The United States Patent and Trademark Office administers trademark rights, federal trademark registrations in the United States of America. Different agencies administer the registration rights in different countries. Now, some of these rights don't require any government agency involvement. Some trademark rights arise at common law. These rights are associated with using a brand in a territory, actually gaining some recognition among the consumers. And before you know it, people think of your company when they think of your brand name, and you have some common law rights. Now, there's another set of rights, typically stronger, that are often associated with a government registration. For instance, in the United States, a federal registration is afforded geographic exclusivity across the country, whereas for a common law mark, you're afforded exclusivity within the zone you're actually conducting business and trade in. So that's an advantage of a federal registration. Different countries have different rules about this, but universally, a trademark is a geographically bounded thing. Now, there are treaties, several treaties in particular. These treaties allow global players to extend their trademark rights from one geographically bounded jurisdiction to another. For instance, the main international system for registering trademarks globally is the Madrid system. Sometimes this is called the Madrid Protocol. Beginning in 1891, a series of treaties evolved to provide a centrally administered system to obtain trademarks in a large number of countries. You'll run across other mechanisms such as the community trademark, which provides for a unified trademark system across the EU member states. This will simplify the process of protecting marks in Europe. But what of trademarks in space? Today's discussion is not meant to be a detailed explanation of the complexities of global brand protection. For this and for how to interface with the different treaties, you need to talk to a good IP attorney. But I want to introduce some of the complexities when we move from this geographically bounded terrestrial framework into space. Now, in my previous work and on my blog, I've talked about the potential value of vessel flags for patent law and the possible relevance of maritime law principles in space. In that discussion, we concluded that the flag of the vessel where patent infringement happens would carry a lot of value in determining which country's patent laws applied. And we even referred back to longstanding maritime law and example cases when patents were enforced at sea. There's a different problem with trademark law. So for just a minute, indulge my speculation here, but think conceptually about how trademarks gain their power. On the one end of the relationship is a product, and on the other end is an actual human being. And this is a little bit different than in patent law when you look at the product and assess it directly against the patent without considering how a person might feel or perceive the product in trade. This human perception issue is going to change our analysis a bit. In trademark law, the nexus of a claim lies in whether or not a reasonable consumer would be likely to become confused in a particular area. Now, as I said, patent infringement is a one-step analysis. Does the device in the location infringe the patent claims? Trademark analysis goes by two steps. One, is there a brand here? And two, would a reasonable consumer be likely to become confused in these facts and circumstances? As you can see, with trademarks, there's an interaction between two parties, a product and a person. Furthermore, in many jurisdictions, you can only secure a trademark registration if you can demonstrate use of your trademark in that jurisdiction. So here's the problem, the challenge this raises in the space context. Specifically, there are no customers in space. Some jurisdictions that might be a flag of convenience for a space vehicle are going to prove very difficult places to demonstrate use of your trademark in that jurisdiction. So you could even say that for the flag jurisdiction, there are no or few customers on the ground. So what is a brand owner to do? Again, this is an emerging area of law, and many questions remain unanswered. But I can give you a few recommendations as to what a brand owner who's worried that other actors might use confusingly similar brands in space might start doing to secure their rights. First, let's think about a US-based brand. Now, presumably, that brand will also use the US flag as their flag country for their space vehicles. What should the brand owner do? So, okay, first, I'll presume the space vehicles are somehow tied back to the Earth. Thus, consider where the customers of that space vehicle are located. Consider where you will be producing and releasing media pertaining to that space vehicle. And consider where your uplinks and your downlinks are. Trademark damages are usually fact-based, and the lost cachet in the mind of a consumer would be associated with consumers who live on the Earth. Figure out where these hurt consumers live. That jurisdiction will be an important one. There's less focus on exactly where do the bad guys do the bad thing, because the bad thing might be happening in outer space. Instead, focus on where are the people who bear witness to the bad thing? Where are the people who are harmed or confused by the bad thing? This, as you may recall, is a bit of a different inquiry than when we're dealing with patents. Now, there is and will continue to be some legal confusion about where a space vehicle is for the purpose of the law. We can make guesses, but this is of secondary import because trademark law is about protecting consumers, and consumers are on the Earth, at least for now. So to conclude, protect your space trademarks where the human beings interacting with the goods and services live. Protect your space trademarks in the ground locations that are going to be closely tied to ground operations for this type of a space vehicle. And protect your space trademarks in the flag jurisdictions, if possible, for your and potentially infringing space vehicles. This one can sometimes be more challenging. But in each instance, realize that your primary effort will be to secure the mark in the terrestrial markets where your consumers are actually located, where the money actually flows to and from in real human pockets, and where you can prove a damages case. So trademarks in space are really not much different than trademarks on the Earth, because there are unlikely to be any consumers in space to get confused in the first place. My only caveat is, when you're doing your conventional brand analysis and picking countries, throw in the most common flag jurisdictions for space vehicles too. In time, the nexus of space activities to conventional Earthbound countries will weaken. And as that happens, there may be new laws and there may be new treaties. But for now, since money comes from the Earth and space is used in ways to direct money among different pockets on the Earth, keep protecting your brands in the way you always have, but give a second thought to possibly securing rights in the country of the flag of yours and competitive space vehicles. Perhaps also In the rare case that the flag varies from the launch site, consider how this vehicle operates. Is there going to be a significant branding opportunity around launch? In that case, you might also protect rights there. But once again, we're looking back to human perception. We're looking back to the earth. And that is all we need to talk about for now. Perhaps when we start having very novel situations, moon colonies, for instance, launching space vehicles going to Mars, well, now our Earth nexus has changed, and the treaty regime will be changed, and we'll need another podcast. But that's all I have for you today. Again, this is Kyle Graves. Find my stuff at spacelawdigest.com, kylewgraves.com, or follow me at Kyle W. Graves on X. Thanks, everyone.